Do you remember the Anna Hazare movement? When the movement started, everyone was talking about the corruption. And as a pressure on UPI, the government has passed the Lokpal bill. Hello friends, welcome to the InNews series of Drishti IAS. I am Ritu and today's session is about Lokpal bill and also the chairperson about the Lokpal bill. So, A.M. Khanwilkar, who is a former judge of Supreme Court, has been appointed as the chairperson of the Lokpal. So, moving towards the points of discussion. First of all, we are going to discuss the news, then we are going to discuss the background about the Lokpal bill and also a brief about Lokpal and Lokayukt, and then why do we need such institution? Because we already have judiciary to make decisions on a particular thing, and then way forward that what are the limitations we have and practice question for prelims. So before that, you have to like, share and subscribe to the Drishti IAS channel. Moving to the news part. So A.M. Khanwilkar, who is a former judge of Supreme Court, has been appointed as the chairperson of the Lokpal. And why he has chosen as a that he should be appointed as the chairperson of the Lokpal? First of all, there is one rule that the chairperson of the Lokpal should consist of from judiciary background, and A.M. Khanwilkar is from the judiciary background. So that's why he is appointed, and in the eyes of the parliamentarians, he is an eminent jurist and his integrity cannot be questioned. So they have found him suitable. So that's why his chairperson has been appointed. Moving to the next slide. Next slide is about what are Lokpal and Lokayukt bill. So Lokpal and Lokayukt Act 2013 provided the establishment of Lokpal for the union and Lokayukt for the state. And they are the statutory body, but they don't have any constitutional status. It means that they can advise and their decisions are also binding in nature, but they don't have court of records. So this is the difference between the statutory body, and also they perform the function of ombudsman. And what is ombudsman here? Ombudsman is an individual, or you can say an authority who checks and balance on the corruption thing and also report on the various corruption issues. So this is a brief definition of the ombudsman. Moving to the next one. The next slide is about why do we need such institution. So in India, we can see that maladministration has acted like a termite in every administration. So in order to improve the maladministration structure, we need Lokpal and Lokayukt in our states or also in the union territories and also for the union government. So there are few problems. The first problem is of the maladministration. The second is the anti-corruption agency. We needed an anti-corruption agency, though we have the CBI, but the Supreme Court had also said to the CBI that it is like a cased parrot. And also many of these agencies are advisory bodies. So this is a statutory body, so its decisions are binding in nature. So that's why Lokpal is important. And also we need an authority or an individual who works for the society with transparency and accountability. So Lokpal and Lokayukt gives answer to all these problems and it find out the solution to all these problems. So that's why we needed such institution in the states also and for the union government also. Moving to the next one. Next slide is about what are its limitations. So the first limitations is that there is no court of records here. It means that their decisions are binding in nature, but you can not appeal to any decisions of Lokpal and Lokayukt to the courts. So it is also free from judiciary. So this is one of the biggest limitation we have in context of Lokpal and Lokayukt. The second is that it is also not free from the political influence, because many times we can see that most of the appointments happen for because of the political influence and political region. So in that sense, you cannot expect any Lokpal or Lokayukt to be transparent and be independent. So that is also another problem. And also the society does not much care about the whistleblowers and they act as a whistleblower. So there should be concrete immunity provided to the whistleblowers. So that's why these are the limitations. And I already have told you the exclusion of judiciary is the biggest reasons and not given any constitutional backing. So these are the limitations that Lokpal needs constitutional backing. Also, it should have a appeasement kind of thing, and they should be provided the immunity. And also there is a definition that in the eyes of the parliamentarians and in the Lokpal search committee, the person should be suitable and it should be work for the integrity. But the definition and the idea of integrity or any kind of qualification is vague. So that creates another kind of the confusion. Though Lokpal has a very good criteria that 50% of its member consist from the judiciary background and 50 from the normal civilian backgrounds. And they all should consist a member from the scheduled caste, scheduled tribes and women. So these all processes are very good in this condition that we had tried to make it more inclusive and so that people from all the communities are heard. Moving to the way forward approach, that what should be the way forward for it. So in order to tackle the problem of corruption, because corruption is highly discussed and we can see that there are lots of corruption is happening in our country. So there should be an accountable authority which looks care of the corrupt activities. So for that we need a Lokpal. But what many times we have seen that many appointments happen because of the political reason. So it should be freed from the political influence. Second, it should not be excluded from the judiciary. The people should have authority to appeal any decision of Lokpal against the Supreme Court or High Court. So we also need these kind of the things. And also many times many states does not have Lokayukt. So there should be the strict implementation that all the states should have a Lokayukt so that people can address their problems. So there should be no vacant seat for the Lokpal and Lokayukt. So this is also the appointment which are made for the Lokpal and Lokayukt. It should be in transparent nature. And the people who are from the political background and people who are the ruling political party should not interfere into such matters. So these are the way forward which has been suggested. Moving to the question part. So the question is, who has coined the term Lokpal and Lokayukt? And your first option is Amen Venkatachalya. The second is Virappa Moily. The third is Dr. L.M. Singhvi. And the fourth is Dr. B.R. Ambedkar. I think this is very easy. You can answer in the comment section. And before that, you also need to know that from where the Lokpal and Lokayukt concept has been come. So it has been come from the Sweden, and in 1809 such concept has been erupted in Sweden, and after that Norway, New Zealand also adopted, British also adopted. In India, the concept came in 1960s, but Lokpal bill got passed in 2013. So there was a long way we had traveled to pass a bill. So this is the brief background about the Lokpal. I hope you like this session. If you have any queries related to this session, kindly ask in the comment section. Thank you.
For more informative content, like, share and subscribe. And do not forget to press the bell icon to get the notifications.